Hello, I'm Vivian Cockrell. I'm Head of Pension Strategy at Rag & Co, and I'm going to be talking to Ian Gordon about the latest thinking in trustee governance. We're going to be talking about the recent cases where trustees' actions have been examined and commented on in the High Court by the judges. And what we're hoping is that by asking Ian to share some of his insider knowledge of those cases, we'll find some advice and tips that will help all trustees to improve their risk management. So Ian, let's start by talking about rule changes. Why do you think they're such a problem area?
I think probably for two main reasons. First of all, there's the importance of making sure that the revised rule actually reflects what the employer and the trustees have intended and what they've agreed. And second of all, really a mechanical point, making sure that the way in which you go about seeking to amend the rules is in accordance with the precise terms of the amendment power in the trustee rules. But in plenty of cases, a classic example would be if the deed says that to amend the rules, you've got to effect any change by deed. Rather than doing that, booklets have been revised, announcements said to members, and the courts have said that's not a deed, and therefore the attempt to amend the rules in that way has not been mechanically effective.
So is there anything, Ian, that the trustees could learn from the recent cases involving drafting errors? And particularly, is there any help out there for them?
Probably most of the cases involving drafting errors are negligence claims against those people who drafted the rules in the first place. Usually the lawyers, but sometimes the actuaries as well. And in those cases, the court is concerned to see whether the instructions that were given to the draftsman were clear, and therefore it's important from a trustee point of view to make sure the instructions given to the advisors are very clear. Also, it's very important when drafting comes back from the advisor for the trustees to make sure and to check there are no mistakes in it, and what's been drafted reflects the intentions of the trustees and also the employer. Recent developments in the courts show a more relaxed approach to issues of, for example, construction and also rectification. So before bringing a claim against an advisor, it may be possible to ask the court to construe the wording in a way in which was consistent with the intentions and the agreement of the trustees and the employer. And the courts are now saying that when they come to interpret the rules, they can go beyond the wording itself and look at the factual background from which they can ascertain the intentions of the trustees and the employer, and that's very useful. Secondly, if the courts can't find their way home as a matter of construction, if you put forward evidence which shows that the wording in the rules themselves does not reflect what was intended by the trustees and the employer, it's possible to ask the court to rectify the wording of the rules so as to coincide with what in fact was intended.
So pensions is such a technical area that quite often claims will involve errors on the part of advisors. But what if that error in the documents say it was a long time ago?
This sort of problem is arising more and more now, really, especially in terms of equalisation post-Barber. Often mistakes are made by advisors in the immediate aftermath of Barber in 1990, and claims against those professionals are becoming more and more time-barred. And the effect of that is that your ability to recover damages arising from that error could be impaired. As a way around that limitation problem, what we're finding is that people are bringing claims against successor advisors, and it's being said against them that when they took on the scheme, they ought to have identified a problem or a mistake that was made by the previous advisor. Then it is said that had they advised the trustees and the employer of that, they would have realised the original advisor had made a mistake. That advisor could then have been sued before the claim against it became time-barred. And what's being said is, because of the later advisor's negligence, the employer trustees have lost the chance to recover damages from the original advisor, and that claim for loss of a chance is a way of recouping compensation for the whole period from the second advisor, precisely because the claim against the first advisor is time-barred.
And investment duties are a particular case in point, and I think a very difficult area. Why should trustees worry about investment duties?
We're seeing now more and more claims coming through based upon a scheme's investment strategy. Often it's because the scheme was overexposed to equities or mortgage-backed assets. Now, although the trustees would be advised by a whole range of advisors, for example, actuaries and investment advisors, the responsibility for formulating the investment policy of the scheme is primarily with the trustees, and they also have to, as part of their duties, take appropriate professional advice at the appropriate time. And we have come across cases where an employer of the scheme and the scheme's new trustees have brought proceedings against the former trustees on the basis that they didn't seek at the appropriate time proper professional investment advice in relation to the scheme.
And what we've seen a lot of in recent years is changes from defined benefit to defined contribution. Is there any guidance out there? Have there been any cases talking about that area?
This really goes back to the first question you asked, in the sense that the important thing when you come to change the benefits from DB to DC is to make sure that the formalities for changing the rules of the scheme have been complied with. I had a case once when the intention was to change future accrual from DB to DC. The amendment power had in it no particular requirement, so a deed, for example, was not required. The announcement went out to members and they signed forms saying, yes, we agree to that. The problem was that the announcement itself did not come from the principal employer, so it wasn't effective. There was a second fallback argument, which was that the members, having signed the forms, did not consent to the change from DB to DC. The problem there was that there was a statement in the announcement that actually was misleading as to their entitlements under the DB structure. Therefore, it was said their consent to the change was vitiated by that misrepresentation, and therefore the change wasn't effective.